Welcome back to Closing Day. I'm your host, Geoff DelGrand, and with me today I've got Chris Harrison from Harrison Law Firm, and we're talking about closing day. Now, one of the things I wanted to ask you, Chris, is besides good looks, what should someone look for in a lawyer?
Well, first of all, Geoff, if good looks were the criteria, I'd be looking for another job. So
Okay, all right.
But thank you. So some of the things that I think people should be looking for, and as with many things in life, price is often a factor. Mm-hmm. And I know that people have certain views of the legal profession. So please don't misunderstand me when I say the price shouldn't be their primary consideration when they're considering who's going to be their lawyer to do the transaction.
Right.
They should be thinking about things like what percentage of the lawyer's practice is devoted to real estate.
Right.
To what extent is the lawyer involved in the file? How many files per month is the lawyer closing? I know of law firms that in busy months are closing, 300 deals.
Really?
So do the math at 40 hours a week and 300 deals in a month, and that'll tell you how much lawyer time goes into it.
Yeah.
Does the lawyer inject a personal touch into the files? Mm-hmm. Does the lawyer meet with his or her own clients to sign the people up? Do the clients ever even get to see the lawyer?
Yes.
There's a lot of factors that go into choosing someone that you're comfortable with, and while of course price has to be a consideration, those
mm-hmm.
other things have to be taken into account as well. So those are some of the things that I would say to people that were thinking about hiring a real estate lawyer.
Right. Yeah, and that makes sense because it's a very emotional experience buying a home. And you want to have some comfort there. So, as you said, lawyer time is important.
It's hugely emotional, and clients need to know that if they have a problem, mm-hmm. that they can contact the lawyer, and they're going to get a response within a reasonable period of time. It is a highly emotional period of time for people. There's a lot of stress on people's plates. They're thinking about, they're worrying about their numbers. I'm selling, I'm buying, this is my mortgage, this is what I'm going to realize, these are my commissions. They're doing their numbers, 8 or 10 times a day for months on end, wanting to make sure that the deal is going to go smoothly. They're moving their children from one school to another, and how are they going to adapt to that? So there's a lot on our clients' plate, and they need to know that if they're stressed out about something, part of my job is to try and take some of that stress off their shoulders.
Yeah.
If they have questions, I encourage them to call or email so that we can, I would much rather spend 5 minutes on the phone with a client and set their mind at ease than have them lying awake for days on end stewing about something.
And that would be a terrible experience.
Mm-hmm.
Now, this is a question that I get periodically, but I think it's important, is if a couple are buying a home, they can own it in one of two ways. They can own it, I believe, as tenants in common, or they can have joint tenancy.
Sure.
It's terms I've heard before, but I don't have a full understanding of what the difference is. So a couple come to you, they want to buy a home. What's the difference between the two ways of owning the home, and what would you advise a couple?
Well, the advice largely depends on their personal circumstances.
Okay.
The way many, if not most, couples would take title to a home mm-hmm. is as joint tenants. And what that means is that on the death of one or the other co-owner, the survivor acquires the deceased party's interest in the property by what's referred to as right of survivorship. Okay. There's a very simple process that, following the death of the one co-owner, would vest title into the survivor's name. There would not be any formal estate process involved. There wouldn't be probate fees to the province of Ontario. It's a very efficient way of keeping an asset out of formal estate administration.
Right.
So the other method, tenancy in common, means that the deceased party's interest would flow through an estate. Now, sometimes you might have couples who are in a second marriage. who each have
Okay.
kids from a previous marriage.
Yeah.
And they're each contributing equally towards acquisition of a home, but they would like to know that their kids are going to receive the benefit of their half interest on passing.
Good point.
That might be one scenario where tenancy in common would make sense. So the distinction really is about death and where the property rights vest on death of the party.
Okay, I see. I mean, I've heard the term, this is how I remember what the difference is, but I didn't understand the details of the difference, is that under joint tenancies, if one of the co-owners passes away, the other person gets the joint. So that was the only way I knew to explain it to people, but now I know the details.
Right. That's exactly right. Yeah.
That's okay.
Although joint has many different meanings.
Well, especially with the new Liberal government. Okay, so we've gone through a bit about the process. The client's going to get contacted. They're going to meet with you to sign up, or with their lawyer to sign up. They get the keys on closing. Is there any other caveats you can think of in there, or is there too many to talk about now? Because if not, I've got another question we can roll to.
Sorry.
I'm just wondering, is there anything other than did I have that process correct?
Well, one of the things that I marvel about the real estate clerk who's putting files together is their ability to multitask.
Okay.
The reality is that in the course of putting together a real estate transaction, there are probably hundreds of sub-steps that the clerks are involved in, right from the file opening process through to closing,
Really?
through to
Okay.
reporting the transaction. Following the transaction, we're required to send out a reporting letter setting out all the details of the transaction and enclosing some of the documents that the client would have signed. In the case of a purchase, it would include a copy of the registered title transfer and the registered mortgage and things like that. So there is a whole myriad of steps. I've way oversimplified, given our time constraints today.
Yeah.
So there's plenty of other things that we could certainly talk about.
Okay, well, I certainly appreciate you simplifying it for us. Now, just a couple of odd questions. One is, what is and you may not have thought this stuff through, but what is the largest real estate transaction you've had to close?
Well, my practice is primarily residential real estate. So,
okay.
So I have offices in Brampton and in Orangeville, and as you know, Orangeville is an area that has homes of fairly modest price right up to multi-million-dollar homes. So I have done the $1 million residential transactions, but I've also done one bedroom apartment style condominium transactions of much more modest.
Right across the board.
Completely across the board. I don't do very much commercial real estate work.
Okay. Yeah, I understand. Commercial's a little bit of a different beast. Now, we did talk just before the break, about firm deals. Now, this I want to get into a little bit, because everyone feels that they have to go in with a firm offer these days. It's really the environment we're in. How does it handle your end? I mean, it seems a little risky to me.
That all depends on what stage of the transaction that I'm brought in.
Right.
So if, as is the usual case, if I'm brought in after the deal is already signed, sealed, and delivered, it doesn't change my approach to the transaction at all.
Okay.
I'm going to open my file, I'm going to put the file together, I'm going to meet the client, sign them up, close the deal.
Yeah.
But what I worry about when people are signing firm deals like this is they're waiving things like home inspections, they're waiving financing. Personally, if I were a seller, I would take some comfort in knowing that my prospective purchaser is taking 2 or 3 days on a conditional financing clause to get their financing ducks in a row, and then waive the financing. But that's me.
Yes. Yeah.
I understand that there's a completely different dynamic in the marketplace right now.
Yeah.
But here's where it might impact people. So if they're delivering that clear, clean offer, not conditional on financing, not conditional on home inspecting, and after I put the key in their hand and they rush over to their house, they stick their head in the attic for the first time and they find black mold.
Right.
They find that there's a leak in the roof. They find that there's a crack in the foundation. Any of these things that might have been turned up by a home inspector's report are things that they've waived.
Yes. Yeah.
So there's a very heavy component of buyer beware in residential real estate transactions. So there's a very good possibility that unless the seller has acted fraudulently and has attempted to cover up or conceal these defects in the property, there's a very good possibility that my purchaser, who's now just taken on a great big mortgage, all of the air is going to go out of their balloon in a hurry when they find out that they've got a $5,000 or a $10,000 repair that they have to do.
Right. Now, I've heard that some purchasers look at it as, $5,000 deposit with the offer. That's their risk. If they back off or back out of the deal, they'll lose the $5,000. So that becomes sort of like the new conditional offer, losing your $5,000 deposit. Is that?
Well, in the the current dynamics of the market are a little bit unusual.
Yeah. Yeah.
In the sense that that's not all that a defaulting purchaser could stand to lose. Sure, you're going to lose your deposit if you default on the transaction. But if the seller now remarkets the property and despite their best efforts, they sell the property for $50,000 less than what you, the defaulting purchaser, had agreed to pay,
Right.
they've just suffered a $50,000 damages claim. So it's not just the deposit that you stand to lose. You could be sued for $50,000 after the seller has resold the home at a lower price.
Wow, that makes a bit of a scary market, doesn't it?
Well, again, the dynamics of this market, things seem to be rising daily.
Yes.
So a lot of that might be driving this belief that that losing your deposit or that a firm offer is the new conditional offer, and that you only have to worry about losing your deposit. That could be true because there may have been 15 other people lining up to put offers in on that home.
Yeah.
But that's not going to be the case forever. So all I would say is, if you do it, consult with your lawyer before you make those offers, and take their advice accordingly.
Okay, well, that's great. Chris, thank you very much for coming on the show today, and thank you for taking a really tough topic and simplifying it, as much as you could under the time constraint so we could all understand it. And I want to thank everyone for watching today. This is Geoff DelGrand for Closing Day, and we'll see you next time.